Good afternoon and welcome. This is a special meeting of the Sunshine Ordinance Task Force called for Thursday, May 5th, 2011 at 5 p.m., beginning at 5:03 p.m. Roll call, please.
Yes, Mr. Chair. Member Snyder? Here. Snyder present. Member Nee?
Here.
Nee present. Member Cotton? Cotton present. Member Manny?
Present.
Manny present. Member Washburn? Washburn absent. Member Knebber?
Here.
Knebber present. Member Costa?
Here.
Costa present. Member Wolf?
Aye. Here.
Wolf present. Member Chan? Chan absent. Member Johnson?
Here.
Johnson present. Member West? West absent. Mr. Chair, we have a quorum.
Okay, of the three who were, there are 8 present, is that correct? Of the 3 who were not here, are there any who should not be excused?
Mr. Chair, you can, as a whole, do it without objection or do a motion.
Okay, I believe we have heard reasons from members Chan and Washburn for their absences. Do you have knowledge of why Member West is not here?
He has not contacted me, Mr. Chair, and Member Washburn has not contacted me as
Okay, I
well.
believe Member Washburn told me some time ago that she has, I believe, some medical reasons for her absence.
Okay.
And Member Chan has contacted us. My inclination is to, without objection, declare members Washburn and Chan excused and Member West, unless we hear otherwise, absent. Without objection? Without objection.
Okay, I need some clarification. So
Member Cawthon?
for purposes of disconnection with the task force, are special meetings counted as meetings, or is it just regular meetings? Are special meetings counted as meetings that can disqualify you if you have 3 absences?
I believe regular meetings are the only ones that count. That's my
what I thought,
recollection.
But
I think that's in our bylaws, isn't it? Member
Yeah, our
Knebber?
bylaws say regular meetings, of course. The clerk of the board has protested that in his letter. He said that was not correct, but I still think the bylaws say
Okay,
it's regular meetings.
Well, the reason I ask is that, as I told you before the meeting, the Library Commission meets on the first and third Thursday, and I have to go as I chair a major library group in my neighborhood, and I just hate to have to choose between the 2 groups. And also, I hate to have to try and make both of them because it's tough.
Okay, just Member Johnson.
When I read the clerk's directive, it was that if we didn't excuse people as a body, it would be an absence. So, for example, we could vote to excuse Member Cawthon, and then it would not be considered an absence.
That's
So that
right.
would be up to our discretion if we want to choose special meetings to count.
But my question is, since this is a special meeting, does it count if in badness?
Unless we vote
That
that you're
I think,
excused.
I believe not, because our bylaws stipulate to regular meetings only.
Okay, so I
That's
don't
my,
think I'm
that's
deserting
my
you
recollection.
on purpose.
Member Wolf is shaking his head. Is that,
Our bylaws.
Member Knebber?
At the last meeting, this is what the big discussion was about, and I had tried to amend it to say only regular, but farther on, it does say special and regular at the beginning, but below it says only regular meetings missed.
So I think we're in good shape then.
I believe.
Okay. Member Monek, did you have a question or comment? Okay. All right, but, so in Member West's case, then it really wouldn't count against him because this is a special meeting. Even so, it would be nice to hear from members who, for one reason or another, cannot attend, particularly for a special meeting. It's very often difficult to get or maintain a quorum, so it's always helpful. Any changes to today's agenda?
There are no changes, Mr. Chair.
Thank you. Mr. Clerk, could you call the first item, please?
The first item is the letter to the Ethics Commission protesting dismissal of task force's complaint against the public library. Ethics Commission complaint number 05-100219.
Okay. I submitted a series of recommended revisions, and you see before you another set of some additional revisions offered, I believe, by Member Johnson. Is that correct?
Yes.
Okay. Member Johnson, could you maybe
Guide you through what I
explain,
said.
guide us through it and explain your reasoning, particularly on your first one?
Okay, there's, what is your reference to the regarding or the crossing out of the ESC? Let me just start with both of those. I believe that none of these, while they may be attorneys, they're not attorneys for the Ethics Commission, and when you document something, I believe that it adds to the confusion to call them Esquire. They're not acting in their capacity as an attorney, and in fact don't have to be an attorney to sit on the Ethics Commission. Now, while we know that, these are something that we want to take into account to have future people not leave anything open to speculation. So their opinion is not a legal opinion necessarily. It's as a commissioner.
Okay.
So that's my reasoning for that. And then the second one is that we are not versus the library. And in fact, the Ethics Commission itself refers to it as a referral of Sunshine Ordinance complaint number. That I copied that directly from what the Ethics Commission calls what we referred it. I also just do not think that it is a wise decision to document this as though the task force is an adversary to the public library. It came within the course of the complaint. While Mr. Warfield didn't bring it, we're not bringing something against the public library. It's similar to the way that an appeals case is handled by an appellate court. They don't suddenly change it to make it the court versus whoever it is that they're holding in sanction for whatever reason happened during the event. So I would just, you don't have to necessarily agree with me, but I would just, even if we change it to some other thing, I do not think it's the task force versus the public library.
Okay. Just by way of information, the only reason I put the Esquires after that, and I have no objection to removing them, on the website, on the Ethics Commission website, where it lists the members, it has Esquires after those particular names. So I put them in there, as a matter of respect, but I have no problem with deleting them.
I understand the respect, but the problem is that they don't in turn provide us with the same respect, so we have to very carefully document because they parse through the words, and I think that we have to be very careful about what we
No, I'm fine with it. I'm fine with it. Member Wolf?
The state legislature prohibits that.
prohibits what I'm saying.
Prohibits your professional titles. And I think there's only one member of the legislature of both houses that forced his way to have his PhD put on the end of his name and then had it then removed.
Is that Senator Yee?
Yes.
Then the next one is that the ethics, I crossed out staff because in the Ethics Commission's memorandum, they say that they had the opportunity to call it to a hearing, the commissioners, and they did not. So I think they're the ones that are choosing not to hear it. The staff I left staff in other places where you put it in here when you referred to their analysis, but they actually are not. The commissioners need to be held accountable for not calling a hearing. They're the ones that make that decision. And then the Ethics Commission's memorandum and choice to dismiss it is not a reversal of our ruling. And they don't call it that. And we don't agree with it, is the gist of my, so again, this is for future reference. If people go back and bring this and they look at it, it will read that the Ethics Commission reversed it when in fact they just dismissed it. That's their version of it. We are not changing our order of determination based on it. And they don't say they're reversing it, they just say they're dismissing it. So that's why I suggested that, and that's the same thing in the other in the next paragraph down. So in another thing that I did in here that I feel very strongly about, and this came up when I was working with the animal rights groups at the Animal Welfare Commission, I believe that this is somewhat of a, I don't want to say legal, but it is somewhat of a very formal response to a true hearing and proceeding. And the terms, phrases like "we believe" and "we argue," those imply opinions. And what we're saying, we believe what we're saying, we believe. Our response is not our opinion. Our response is how the Sunshine Ordinance Task Force has chosen to interpret the law. So, I do this all day long at the law firm, and the attorneys never leave open. Member Snyder could, chime in at any time, but attorneys seldom leave open the concept that it's an opinion. Make them come back as though you're stating it as fact. That's what I've learned over the years. So I crossed out those things. There was one thing in there. I tried to, I understand that some of it is the style of how different people write, but I think I crossed out "were" and put "are" because they are still specious. Then, do you want me to go on or questions? The next page, like I said, the task force believes, and I think what we want to say is Mr. St. Croix errs in his interpretation. Just say it out there. We don't have to think that it's an opinion. Then I put in the paragraph that's on, I had to write it because we didn't get this came into us in a PDF. And I added this paragraph because my understanding of what Mr. St. Croix was saying was that the 6721E allows one hearing on determination that someone has to attend. Not just that it was the full task force, but that it was the hearing at which a determination was made. So should the Compliance and Amendments Committee make the determination, I think they would have ruled that that particular committee could make it. The gist of that memo was that they were hunting around for a space or a phrase that says that a representative had to attend a second hearing. They're implying that it's only the first hearing of determination. So I thought if we had both of those arguments in there, the one where you're referring to the task force, the full task force, and adding in that the task force has set a precedent that any hearing relates to all the initial hearing and all the subsequent hearings. And I used some of your language from, saying that the subcommittees are part and parcel of the work of the task force. Then again, at the bottom of the second page, I don't know if you'll agree with me or not, but the idea, I didn't want to leave open the interpretation. I didn't want to give them an out that we've never watched you, so we don't know if you give a careful attention to the process. We do, and they can listen. So that's why I didn't want to give them an automatic excuse to, they don't even have, if they're going to make an excuse, I want them to have to come up with it on their own. We're too busy, we have family, we can't listen, or whatever that might be. And then the last paragraph, I think what we're saying is that reconsideration of this dismissal is warranted. Again, I changed complaint to ruling because it is a ruling. We're not just complaining, we made an order of determination. So all of this is just to make it crystal clear if someone in the future uses this or looks at it. So because that's what they seem to have been doing, is taking our words and manipulating them. And then whenever somebody writes to a judge, whenever the attorneys write to a judge, they put "respectfully submitted," and I wanted it to seem really formal. And I wanted it to appear to be coming from the person we voted in to represent us as the full task force. So that's, and I put in "referral" because I thought that it was missing right there.
Understand. I don't think on behalf of the task force is necessary because we've already got the task force letterhead at the top. I think that indicates pretty clearly that I am speaking for the task force. Member Wolf?
Yeah, in the last paragraph, the word reconsideration is a specific action word. You're asking them to put it back on, take a formal action to reconsider the item, put it back on the agenda just before a vote, and
That's what Chair Nee is doing in that paragraph. He says, review at the commission level the task force ruling against the public library.
But I don't know that just saying the word reconsideration that one or more of the members of the commission will know what that means. It may just mean in your own head reconsider it versus taking a procedural Robert's rules, vote, put it, proper procedure to get it back on the agenda. So I would maybe expand on that somehow by stating that reconsideration actually means we want you to do something.
How about revisit? Revisit of this dismissal is warranted.
Well, I mean, is that the intent? Or is the intent?
Well, if you read Chair Nee's item number one, he asks them to, because the thing that happened is that the commission did not choose to review it. So Chair Nee is asking them to have the commissioners review it rather than simply accept the staff's dismissal. So that's why I put that reconsideration is that they're reconsidering their failure to take it up to the commissioners.
I'm just feeling that.
But I don't mind changing it.
That the word, like review, is passive. It's not an active word. That it's more like we want them to do the deed. We want them to look at this, and we want them to actually enforce it.
Wasn't that what Chair Nee is at? That reconsideration is warranted, and then he goes on to say, for all of these reasons, we're urging you to review it at commission level. I think that's what he's saying right there. No?
Yeah, but they could review it. Doesn't mean they have to do anything.
Member Costa?
What about just saying formal reconsideration?
How about a formal hearing? A formal hearing of this dismissal is warranted, or commission hearing. A full commission hearing of this dismissal is warranted. I don't know.
Member Knebber?
I see where you're coming from, but I think that reconsideration is as far as, I understand you want them as a commission to take it on, but we don't have the authority to demand that. What we can say is, we need you to look this over, commissioners, formally, to review what the staff has dismissed, right? So I think reconsideration is probably the best word, as reconsideration as a commission.
Member Wolf?
Just in response to that, my concern is that had they been following the rule, the procedure properly, then they would have just taken our order of termination and enforced it. And I think that's what we need to ask them to do.
Well, if you can come up with a stronger word, this is certainly the time to do it while Dennis Herrera is in trouble with Alex Turk. So this is the time to do it because it'll be a lot harder for them to defend it.
Right. So, I think the word review just means that they'll look it over versus actually taking any action on it. So I would maybe change the word, change it from review to take action at the commission level. The task force's ruling against the public library to the commission.
How about enforce?
Or enforce, right. Enforce, yeah. Use the word that's in the ordinance, is enforce.
So if we change that, I think reconsideration is fine at the beginning if number one is changed to enforce at the commission level the task force ruling.
Change review there.
Yeah.
To enforce. Because that's the reconsideration we want them to do. We sent them a ruling, and their role is to enforce what we ruled. So the reconsideration is, hey, this is what we sent you. Number one, you should be enforcing this. Number two, future level, you should be enforcing. In future, you should be enforcing.
And then in number two, again, replace the word review with enforce. And make it standard practice and policy henceforth to enforce at the commission level all such referrals that come before you.
The second one.
Okay. What I will do is incorporate all these fixes and bring them before the task force at our next special meeting, which I have tentatively scheduled for 2 weeks from today, although I've had one request that maybe we see if there's another day that where we could accommodate more of the members schedule-wise. I will send us an email on that forthwith when I get home, or shortly thereafter.
So we're going to wait to send it, to vote on it.
Yeah, we'll wait
Okay.
and, get a final thumbs up. Further discussion. Is there any public comment on this item?
Good evening, task force members. Thomas Piccarello. I would like to see, you have a quorum tonight. I would like to see the letter go out tonight. The task force members have all been invited to give their input. And I don't see any reason there should be a delay in the letter going out. Just a couple of comments on the letter. I do like the proposed changes by Task Force Member Johnson. Makes the letter stronger. On page 2, though, you talk about Mr. St. Croix's logic. Actually, his logic is correct. I mean, in the sense that a proceeding by 1 or 2 members of the Ethics Commission, that's not a quorum. So really, they don't have the authority, 1 or 2 members of the Ethics Commission, and it doesn't carry the same weight. So I wouldn't put that in this letter. I mean, participation by 1 or 2 Ethics Commission members is not a quorum, so this doesn't carry the same weight as a quorum of the Ethics Commission. And finally, let me say this. I think the letter should go out. The signatory should be all task force members who agree to this letter rather than the chair on behalf of the Sunshine Task Force. It gives it more strength and support. So what I'm advocating is that, A, there's no reason that this should be continued another 2 weeks. You have a quorum, and if you should wordsmith, decide tonight, and the letter should go out, and then it should be signed by all the task force members that agree to the substance of the letter. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion. I'm sorry.
I think in addition to that, I think you should send a letter to the Board of Supervisors, because I definitely am getting the impression that the Ethics Commission doesn't have any desire to enforce the Sunshine Ordinance. And then I also think you need to send a letter out to the media as well. So those are my theories.
Thank you. Is there further public comment? Seeing none, public comment is closed. Task Force? Member Johnson?
I don't know if you do want to CC it to anybody other than the Ethics Commission, just so they know. But it's my understanding that the Executive Director of the Ethics Commission does have the authority to assign just 1 or 2 members to a hearing under the charter. I think it's like 15105 or something like that. There are rules where they can, because remember when we were going through their standard, their regulations that they're proposing, there was some language in there about how it could be heard before the full commission or just before 1 or 2 commissioners, or they could appoint some outside person.
Further discussion? Okay. my inclination is to stick with my decision that I made a few minutes ago to redraft this, incorporating the fixes that we've all agreed on, and bring it back. Without objection? Member Wolf?
I object. I think we should just decide that this is what's it, with the changes, wordsmith it, clean it up, reformat it, whatever, send it out.
Yeah, I would
I
agree
don't
with
think we need
Member
to
Wolf.
discuss it again.
I agree.
Okay, consensus, that's consensus, and that's what we'll go with. So I will do the necessary wordsmithing and send a copy to Mr. Rustum and to all of you, and we'll get it moving. Mr. Clerk, could you call the next item, please?
The next item is determination of jurisdiction on complaint filed by Andrew Cisneros against the San Francisco Municipal Transportation Agency for allegedly failing to release information related to a driver cam.
Okay, is jurisdiction being contested?
No, Mr. Chair.
Okay, Chair will entertain a motion for
I move we find jurisdiction.
Second.
moved and seconded. Discussion? Is there any public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder? Aye. Snyder, aye. Member Cawthon? Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Caneba?
Aye.
Caneba, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes. Motion passes.
Motion passes. That takes us to the substance of the complaint, Mr. Cisneros. And I would ask that the parties in interest, and anybody else who wants to comment, move toward the front of the room so that if we have questions, they don't have to feel like yo-yos moving back and forth, or at least a little less so. Mr. Cisneros, thank you for coming, sir. You have 5 minutes.
Thank you, task force members, for hearing my complaint tonight. First, let it be noted that I'm not here to violate any privacy rights the MTA has or that I may have. I'm here because I filed a complaint for a request for a document about a report an SFMTA official requested in the course of all due business. The request was made on February 9th to Caroline Celaya. It was denied based on personal privacy laws. It's a report that my superintendent had requested, a report being done on a coach about tampering. I don't see that the response given by the MTA is valid. They say it's an invasion of personal privacy, but whose privacy would I be violating? The buses? It is a record that was previously received or created by the department in the order and course of business, and that was not attorney-client privilege when it was previously written. They didn't keep withholding to a minimum. They could have gave me the report and redacted certain things that were private. They never did. They failed to give me proper justification for withholding. I also believe that they're in violation of the California Public Records Act, where there is selective disclosure. There should be no selective disclosure. Many times, the MTA comes before the task force, and they have no respect for the ordinance at all. They say they don't know it. They don't care. There's nothing punitive levied against them. And it's just another day at Muni. We'll give it to you when we want to give it to you, if we want to give it to you. So I really feel at this point that the task force should vote that the document be produced, because it would exonerate me of any wrongdoing. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Thank you for coming, sir. You have 3 minutes.
Good afternoon, Task Force. My name is Dorian Maxwell. As you know, in my case that came before you, the SFMTA had finally gave me the document after the due process has transpired in my matter. Basically, I want to echo what Mr. Cisneros has said. The SFMTA has no respect for the Sunshine Ordinance. And as you can see, Mr. Hill lied before you last week at the hearing in respects to my hearing, along with Ms. Chambers. She lied before you also. And then this document finally surfaced. I feel that Mr. Cisneros, if this document would help him, just like the document that they withheld from me, exonerated me, I'm pretty sure that this document would have exonerated him. And the SFMTA's practice, anything that the operator can use to help him in his defense, they withhold it. And the task force tonight should make a determination that they produce this document and refer this along with my matter to the Ethics Commission, and also send a letter to the Board of Supervisors letting them know that the SFMTA business practices in respects to the Sunshine Law is being violated. Also, send this to the State Attorney General office, because as you can see, along with my case, which made the New York Times, that they were withholding creditable information that would have exonerated a person. And this practice needs to cease and desist effective immediately, and someone needs to be aware of it. Someone needs to put the screws to them and let them know, hey, stop doing what you're doing, because you are violating rights. And this could lead up to lawsuits against the city. And it's negligent for behavior on this at this magnitude that creates unnecessary litigation towards the city. And this has to cease and desist, and the MTA needs to be held accountable for their irresponsibility to the Sunshine Ordinance. To me personally, ignorance of the Sunshine Law is no excuse. And that's the way it should be. I mean, that's how it has to be. Somebody has to put the screws to these individuals or properly train them or educate them on how to conduct Sunshine Law if they don't know.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Excuse me, you've already spoken. Please be seated. Seeing none, is the respondent present? Thank you for coming. You have 5 minutes.
My name is Caroline Salaya. I'm the Assistant Board Secretary at the MTA and also the Sunshine Ordinance Public Records Request Coordinator for the agency. We did receive the request from Mr. Cisneros on February 9th. We had 10 days to respond. That fell on the 19th, which was a Saturday. It was the President's Day holiday, so we responded on the Tuesday, the 22nd. We did produce one document. It was a photograph, a copy of a photograph, and we declined to produce 2 other documents that I received from staff in response to this request. One was an email chain, and the other was a video. Both had been placed in personnel files of not just Mr. Cisneros, but another city employee, another MTA employee. And in the past, when Mr. Cisneros has asked for his personnel records, we were able to provide that as he signed a waiver releasing his privacy interests. But we couldn't do that for this other employee because both documents, both items contain not just Mrs. Cisneros, but also for another employee, and they were in the personnel files of both employees. I did ask if it was possible to either redact or to get the video so that we could only have Mr. Cisneros, but unfortunately it's only a 6-second video, and so they were unable to cut it, to redact it. And same also with the email. The whole email chain was in the personnel records for both employees. Let's see. I also learned recently that the 2 documents that I'm describing were provided to Mr. Cisneros under the grievance process. He had filed the grievance, which has different rules than the public records request. So I do know that he did receive those 2 documents, and I understand that there is a third item that he was seeking. And I checked with staff. It turns out that in part of the email chain, instead of actually responding to the email, staff picked up the phone and called the other employee, the other staff person. So there is no actual physical response to that particular email. And I believe that may be what it is that he is seeking, but it just doesn't exist. So, thank you.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter with the task force. Member Wolf?
Ms. Zelaya, please. Okay, a number of things. So you said that the photo was produced. We have we have a photo of it. And then you said that an email chain and video was not supplied. And I appreciate that you had requested if any of it could be redacted. I find it a little difficult that 6 seconds of video would be hard to blur somebody's face out over the course of maybe 16 hours. Would be a little more painstaking. I do that work myself. 6 seconds should be fairly easy to manage. And as far as the email chain, why couldn't the names of the people that you feel need protecting be redacted, and the pertinent information that is public be retained?
I actually don't make the decisions myself. Whenever I'm presented with information from staff, I turn to our city attorneys and ask them for their opinion. And when I asked them to check, they checked with staff and they said that there was no way to actually redact that information. That's what I was told.
But they offer you an opinion, but who ultimately makes the decision?
The usually it's the division head.
Who is the division head?
That would be for Human Resources, Deborah Johnson.
So you're not involved in making those decisions?
Sometimes I am, sometimes I go to
in
the
this
division
particular
head.
case?
I was told that we couldn't do it, so no, we didn't do it.
You were told by who?
By staff, that there was no way to redact the information.
Which staff?
I'd have to check back through my records. I don't have that with me, I'm sorry.
You don't?
I don't have the name of the person. I've answered 100 of these, so I did a lot of research, but I actually don't have that information. I apologize.
Okay, you also claim that some documents are not considered under sunshine. They're considered under some other procedure or form of documents.
Grievance process, which I don't work in labor relations, but I do understand those are separate rules that they go by.
Do you have any citation that shows that they're protected from disclosure under sunshine? Because sunshine declares that it overrides local law, and unless that's not the grievance procedure is not local law, and there's some other provision that you can tell us that would protect that information.
Yeah, I don't have the citation. It's employees' privacy rights is what I understand it to be for the public records request. But I know that it was provided under the grievance process, and I don't know what they cited to produce it under that.
Okay, and Mr. Cisneros testified that the documents that some, if not all the documents, I don't know how many, that he requested were available or public prior to the grievance procedure or any personnel procedure. Is that true? Were there documents available prior to? Well, let me ask it a different way. When did you determine that the documents that you had in your possession needed to come under a different classification? So
When we
under,
sent the letter on February 22nd.
so on February 22nd. Okay. So, so on February 22nd. So prior to February 22nd, what documents did you have that you could have provided Mr. Cisneros?
We couldn't have provided the video or the emails, but those are the two documents that were
Why
given to me by
couldn't
staff.
you? Why couldn't you?
Because they were personnel records from another city employee, another MTA employee, and it would have infringed upon that employee's privacy rights.
So are all drive cam videos considered protected?
I don't know the answer to that. I don't work in security. I'd have to check with security staff.
Well, but in this case, we're talking about records with regards to this drive cam.
There were two employees on the drive cam video.
Well, he wasn't asking for the video itself. Oh,
He
he
was
wasn't
asking
asking for
for-
the video. Say any and all documents related to the drive cam. Wasn't asking for the video itself necessarily.
But it was related, so that's why staff did turn it in.
Well, that's my question is if he made his request on the 9th, 10 days from the 9th is the 19th. So because he said that it was a holiday and it went over to that Tuesday, if you made the decision on Tuesday at the deadline that you're supposed to hand over the information, you made the decision at that time, then any of those documents available prior to the 22nd would be public, considered public, and not protected. I mean, I'd like to hear some justification that they were protected on the 9th. You testified that on the 22nd is when they made the
I'm not certain
decision.
that staff provided it to me on the 9th. They may not have provided it to me until the Friday prior. I'd have to go through and see when staff gave it to me.
What is your
When I
position?
ask staff to provide it, they don't automatically turn and give it to me that very next day or the day that we received it. It may be a few days.
What is your position with the SFMTA?
Assistant Board Secretary, and that's my title, and I respond to public records requests on behalf of the agency that don't pertain to media.
Your board secretary, board of what?
Our Board of Directors, Assistant Board Secretary. There is a Board Secretary.
Okay, so, I'm a little confused because it seems like the request wasn't made of the board.
No, it wasn't. That's actually just my title. It actually has nothing to do. I'm also, this isn't my title, but I am not necessarily the custodian, the coordinator for public records responses for all public records sunshine requests for the last 4 years.
So you're like the public information officer, would you say?
That I'm not, because that usually relates to media.
Okay.
This is specifically for public records requests. Whenever a request is made of the agency that isn't pertaining to human resources, HR, or media, it is meant to come to me. And we are in the process of updating a memo to remind staff, considering what happened at the last meeting, so that all staff are aware of this. Been doing it for the last 4 years, and there have been new employees. So we're getting a new memo out to remind staff.
I'll stop there and let the other members have an
Member Monet?
So just going back to the email chain that was requested, Ms. Zelaya, for clarification that it sounded like it had information of other personnel that you...
That is correct.
Right. So again, practically speaking, could it be possible that this, what seems to be a critical, important requested email chain be printed out, and then that information that you would like to be protected be redacted, completely blacked out, and be provided that way, so that what's public information, what's requested, be made available that way?
I'm happy to go back to the city attorneys and get their opinion and see if there is a way that we can do that. I was told when I asked that there wasn't, but I'm happy to ask again. And I was told also that he has already received that, but through the grievance process, just not through the public records process. So I understand he has it, but I can certainly go back and see if there's a way to do it so that it's provided through the public records process.
Right.
Member Snyder?
Ms. Zelaya, I wanted to ask about the video footage. So was the video footage withheld because it's not technologically possible to blur people's faces, or was it held because to show withheld because to show their faces would have been a violation of personal privacy?
The second one, because it would have been a violation of personal privacy.
So it would be technologically possible to blur their faces, but
Please be seated, ma'am.
so is it technologically possible to blur people's faces out?
I apologize, I'm not a technician. I don't know that our agency has that capability. I don't know.
But the basis for the withholding is that it would have been an invasion of personal privacy to release
Right.
the footage with those faces. Are these cameras that are on buses? Where is this camera located?
I believe it is on the bus.
So this would have been footage that was shot on a public bus.
Yes.
So what I don't understand is why footage of somebody on a public bus in a public setting would be, why would that be a violation of personal
Because it's an
privacy?
employee.
Well, I understand that, but
And-
if an
The
employee
video
is
placed in
standing,
the person's personnel file. So whenever you release personnel files, you have to get the employee to waive their privacy rights, which Mr. Cisneros could do for himself, but he couldn't do for this other employee.
well, but he's just asking for footage. It may be that the footage resides in somebody's file, but that's not the only place it resides. It resides in the camera, and it resides in the records of MTA in whatever capacity. So, well, anyway, so the basis of the personal privacy is of the personal privacy withholding is that the footage is in the personnel file of an employee of MTA, not that
Correct.
that the footage itself to release the footage itself would constitute a violation of personal privacy because of what it shows or because of where it was shot. Does that
Because
question
it
make?
shows the other employee.
Okay, but
Member Snyder?
Yeah.
May I interrupt this?
Please.
quickly?
Member
Is
Member
this,
Knebber.
we have a question of, so this picture that comes, I presume this picture is from the same camera. This is a still video from that same camera?
I believe so.
Okay, so were these employees engaged in work? Were they on the clock when these videos were taken?
I don't know. My colleague may know. Ayn Antonio is here. She's the superintendent.
Actually, I'd like to ask Mr. Cisneros. Mr. Cisneros, could you please approach? I just want to know when this picture and the video were taken. Was it on the clock? Were you on the clock at this time?
Yes, I was in the course of the job.
Okay, thank you very much.
Just to make
Thank
it clear,
you.
I'm
Please
only
be
asking for
seated.
the report.
Please be
I
seated.
understand.
Okay.
Thank you.
Member Johnson.
Mr. Cisneros, I do have a question for you.
Thank you, Ms. Johnson.
Were you, Ms. Zelaya said that you may have already received the video and the document?
I have, but I need the, I think I gave it to Mr. Mustin. There's an email from Ayn Antonio requesting the safety department.
You want their you want to see what their
No, I want to
copy
see
is?
the report on the tampering that would exonerate me.
Were you allowed to review the file?
Not the report, they said
Okay.
it didn't exist.
No, but were you allowed to, has the MTA allowed you to physically review your own personnel file with the video and the,
Yes, I have that, but I don't have the report on the tampering. That's what I'm here for tonight. And I'm sure, if you don't, I gave it to Mr. Mustin. We redacted, it's an email chain, and it says, Emily, Coach 8344 is on the 47 line right now, but I'm in the process of trying to get that coach brought in so video could be pulled. Paul, FYI, so you can secure coach, please check coach to see if camera was tampered. With an extent to tampering, I need a report on that. Now, that was a request by an MTA official to the safety department, I'm assuming. They're saying that
so that's the email she says that they responded verbally to, as opposed to.
Well, it says, well, that's subjective how you want to interpret
I'm just
it.
saying that that's what her response to you was, that they're saying that
It's
the
personal.
report was verbal. But were you allowed to review, did the MTA allow you to review your own file, including the video and the email chain?
Ms. Johnson, If it wasn't for the Sunshine Ordinance, I couldn't have submitted a cornucopia of evidence that benefited me.
But did they allow you, you know, what I'm
They
getting?
they only put out there what benefited them. And they allowed, yes,
Because-
they did allow me to look
Excuse
at
me,
what they had.
Mr. Cisneros, you were asked a direct question.
Yes,
Could
they
you
did.
please answer the question
So did you
directly?
review the video?
Yes.
So, and you reviewed the email chain that they're just, that you, with the exception of the report that they claim?
Exactly.
Okay. Because one of the, could someone direct me to where that, what he just read, what page?
Back at
Page 22.
Ms. Zelaya?
Please
the-
approach.
Is there a person, whoever received the verbal report, is there somebody available who can verbally, has that verbal information?
I don't know the answer to that. Is it okay if my colleague responds to that? She thinks she may be able to.
If she can answer the question, yes, please have her approach.
My name is Ayn Antonio, and I'm the superintendent for Kirkland Division. I was the one who had sent that email to Paul Williamson. Paul Williamson is the maintenance superintendent for Kirkland Division. And so at the time I sent that email to him.
Is there someone available? Is there someone available who could give the oral version of whatever the report was? Where is this information that transpired based on this inspection?
There is, all he did was after I sent him that email, he called me back and said, there's no, see, what I was looking for was...
What did he say to you?
He said, he said there was no evidence of tampering, because what I was looking for was, when we watched the video, we thought there was a screwdriver that was being used to tamper with the drive cam. And so I was thinking that, okay, if there was a sharp object that was being used, then you would see some markings on the drive cam. But he came back and said to me, no, all this person was doing, at that time we did not know it was Mr. Cisneros. It had to take us, in viewing the actual coach video, to determine it was him, and admission by the other operator as to who that person was. You have to remember, this bus, 8344, did not belong to Mr. Cisneros. It belonged to, it was not assigned to him at that time.
Well, I'm just trying to find out. We cannot
Okay.
have this. No, we cannot have
Okay,
this
I'm sorry.
argument
Right.
about what happened.
Right,
That's enough.
okay.
That you reported that there. So the information doesn't
Yeah.
exist on a document,
It
but
does
you
not
just
exist.
reported it. And I mean, that's what you're
Right,
claiming.
right.
The difficulty here is that. You know, in employment law, there is some confidentiality associated with the other employees. So they do have to allow you to review it because it's your own file. But I'm not certain they have to actually hand you a copy of it, depending. Now, those cameras are at Muni all the time, and those cameras distinctly say, warning, you may be videotaped or audio recorded.
Mr. Cisneros, please be seated.
So there is that what do you want to call a waiver of confidentiality. So I don't know how that works outside of when the bus is not in use, but that sign is on there. So.
Member Knever.
Well, I would contend too, since it is working and since it is on the clock, I don't think that is a private act. I mean, it is working, it is on a bus, it is videotaped. I don't think there is any confidentiality associated with that.
Member Snyder.
Yeah, I think it's actually even broader than that. I don't think it matters whether it's on the clock or working. I think the only way I could see the footage on from a camera on a public bus being considered private is if the bus were parked inside a warehouse where the people on the bus understood that the public would not be able to see them. I mean, the measure for whether there's a reasonable expectation of privacy generally is whether the person who is claiming that privacy can be expected to be seen in public. So if people on the bus could be expected to be seen in public, they don't have an expectation of privacy generally. And so I think any of the footage from that camera on a public bus, I think it's hard to make a claim for privacy. I think what MTA is arguing is that because this video was contained in a file which is not subject to disclosure, the video itself is not subject to disclosure, and I don't think that's correct. I think the video itself is subject to disclosure so long as there's no potential violation of somebody's privacy rights, and I don't think that's possible for the reason I just explained, unless the footage was taken, again, I said, in some context where somebody wouldn't have an expectation of privacy.
Members Wolf and Member Knebber.
So with regards to the video, Mr. Cisneros is not asking for the video. He's asking for records relating to the video.
But wasn't video partly what he was asking for?
No, read his complaint again.
No, I understood. I know the complaint just
Yeah.
says records pertaining to the video, but weren't there stills? There was some of it was even released and were stills.
Right, but again, but if those are printed records that are part of the record,
Yeah.
that's one thing. But the actual video itself was not what he asked for.
All right.
Okay, he's asking for what he's really looking for, what Miss Antonio had just testified. You could see it in his body language that he got the answer that he wanted. Okay, if you want to talk about the video and being public, let's take a look at the video that was released by the public defender on. Police entering public housing, public housing. That received city funding. It's a camera that's in the hallway. They know they're being videoed, and because the police department wouldn't release it, he went ahead and released it himself because they wouldn't take up the issue. So it's public information. But the records that he's looking for, that he specifically asked for right now, was this report that Ms. Antonio had requested of Paul Williamson's regarding the tampering. And she testified that there wasn't any. There wasn't any report. So I think in Chair Nee's questioning, I think it was either Chair Nee or Member Johnson in questioning whether Mr. Williamson had produced any documentation. Well, let's ask Ms. Antonio. Ms. Antonio, if Mr. Williamson said that he saw no sign of tampering, would he then not have to document that? Whether there was or not, shouldn't there be a record from an investigator?
If we had gone, I think the way we had done the charges were not based on the damage of the equipment. It was based on a violation of our rules on what to do with the drive cam.
No,
so I would have,
but
I
that's
would
not
have
my
asked,
question.
I would have asked him for a written
But
report.
but that's not my question.
Okay,
Ms.
go ahead.
Antonio. My
Maybe
question
you
is
could
what
repeat
is
it,
your
yeah.
standard procedure? When an investigator is either called out to check on something and asked to report back, and either find something, if he found something, would he had to make a written report?
Yes, if he
Okay.
found
If
something.
he found nothing, would he have to make a written report?
Um,
Do you not require that?
Unfortunately, I don't think that there is a standard procedure for that. If he found something, I would have asked for a report. I would have requested him for a report from him, but.
But it sounds like
yeah,
if you don't, it sounds like
I see what
if you
you're saying.
find nothing
Right.
and there's no written report that we found no sign of tampering, and it's just left open in the air, then it leaves the employee without any evidence of anything. Then you have to drag Mr. Williamson in for testimony.
Right.
Okay? And what happens if we drag Mr. Williamson in for testimony here, and we ask him, and he says, "Oh yeah, I submitted a report saying there was no tampering." What are you then going to say?
But he did not submit a report, though.
Okay.
And I understand what you're saying,
Okay.
and I do appreciate that. You know, you are right. There should have been a written report, whether, you know, there was or wasn't, and we should have done that. I think at the time my focus was, like I said, because we had taken, it was a different way we had done the charges. It was more in violation of what our rules were in terms of what you actually do with the camera. So I just, you know, didn't ask for the report or like I said, you know, it was a telephone conversation.
Thank you. I've just one last question for Mr. Cisneros. Can you please come up? What documents exactly do you need that you feel that you need right now?
The report that Ian had just asked Paul Williamson to do on the extent of tampering. It would exonerate me of any wrongdoing. I've been through administrative hearings already on the chopping block. I believe this is retaliation.
Okay, that's all I wanted to know. So one last question, Ms. Antonio, would you be open to writing a final report that there was no tampering found? That's your testimony here today, on the record, public.
I can ask Paul Williamson to, because he was the
You're
one
his
who.
supervisor, right?
No, I'm not his supervisor. We're actually peers.
Your peers, okay.
So what I can do is, because I never looked at the drive cam video, the camera itself, I can request one from him as to what he found when he checked that drive camera itself, and you know, it's not a problem.
Okay, thank you.
Member Johnson, Member Kneber, Member Costa, Member Snyder.
I just wanted to know if there are these cameras regularly, it says logs of maintenance records and inspections, are they regularly inspected?
I cannot answer that question because I am not from the maintenance department, but
you don't know?
I don't know to what extent they have that, or if, because see, the drive cam belongs to another company, you know, who we contract it out with. So
it's contracted out?
The way I understand it, but I really can't answer that question. I'm sorry.
And then my last question, Ms. Salaya, you had mentioned an email that could not be redacted. Have you yourself seen the email? What I'm getting at
yes,
is, do you
I
know
have seen
what
it, but
I redact documents all the time. That's what I do to get paid for. I can't imagine how it could not be. How is an email unable to be redacted? I'm trying to figure out what, you know, the justification of withholding a document. I don't understand how, you know, can you explain the reasoning how something couldn't be redacted? Are you saying that you'd have to turn over a blank document?
I think that's pretty much what it amounted to.
Because
of the conversation in the email chain. It isn't just one email, it's a chain of emails.
So the only thing that would be remaining would be the to's and the froms?
Right, the date, I guess.
Okay.
Can I jump in?
Member Kneber, Member Costa, Member Snyder.
All right.
So I think that we pretty much have a clear picture of what's going on here. My only concern still is the idea that all records having to do with the driver cam, as we found many times before, oral information is disclosable record. The information from Miss Ann, I guess, Antonio, is part of that record that he requested, and that was not given until this meeting. Oral information is considered a disclosable document. Number two, I think all parties know there's more than one person involved. I think redaction only means taking out names to make public. I have a hard time seeing how emails cannot be redacted again, as Member Johnson says. Once you take out the names, it fulfills the requirement of privacy under all ordinances.
Member Costa, Member Snyder.
I would echo that the sentiment that seems to be prevalent about the email redaction. And I also just sort of wanted to ask Ms. Antonio if, in addition to requesting that Mr. Williamson document the report, you could also document the fact that that was the information that was given to you. And
I can do that,
We
right.
can't really ask them to create a document. I feel uncomfortable with that. I'm just saying, it,
No. Member Johnson is correct. Member Snyder.
Ms. Celaya, can I ask you a couple questions? So I'm a little slow on the uptake here, but I'm having the same question with the emails that I had with the video, and that is, are you saying that it's technologically not possible to redact the information from the emails, or are you saying that if all of the information that needed to be redacted was redacted, there'd be nothing left?
That's the case. I think a lot of times when items are placed in personnel files, it could be because of discipline issues or, I mean, there's reasons why documents are placed in personnel files. And that would be why we'd have to.
Okay, so you're saying that because it's in the personnel file, it cannot be released?
Right.
Period. Anything that, so I've used this example before, but if we put the Declaration of Independence in the employee file, you couldn't release that just by itself? No attendant notes or anything else attached to it, just the Declaration of Independence? That would not be releasable?
We'd have to check with the employee. If that employee asked for that record and waived his rights, that employee could receive it. But another member of the public couldn't.
Okay, so thank you. Mr. Cisneros, I had a question for you. Can you explain, let me start again. Were you looking for video when you asked this request? Or were you expecting or asking for any video in response to your request?
No, I've seen the video. I was looking for the report.
All right, so the video is not part of your request?
No, the video showed, it exonerates me also of any tampering.
But you weren't asking for it, is all I'm
No,
asking.
I was asking for it specifically. That's why I gave Mr. Mustin that email and redacted everything else that was on that page. That Ms. Antonio asked Mr. Williamson on a report on the extent of tampering. That's what I want.
Okay.
And they refused. They said it was personal and private.
Okay, thanks.
Thank you. Member Johnson.
documents that are already public are not confidential just because they're in somebody's personnel file. So I just want to throw out there that the way I just said that we can't ask somebody to create a document, which makes me uncomfortable. It makes me uncomfortable that that was your answer and the judgment of what can be redacted on the email. And now Mr. Cisneros can, always take the information that's public here and make his own request for, that information. Plus, it's here on our audio. That's.
I just want to add one comment to Ms. Zelaya. You indicated that you would get with the city attorney regarding possible redactions. I don't think that that's where you should go. I think that the proper party to address that would be on your technical side. I mean, the city attorney has already advised you on the personnel privacy issue. So that's and that's something we already know. What we don't know, and what you say you don't know, is whether it's possible to redact, to make redactions from the file that's being requested, to the extent that the rest of the information in that could be released. That's where I would suggest you go, is to your technical side. And as I am not an expert in high tech, but it seems to me that even with my low amount of expertise, I could probably do the kinds of redactions that we're talking about here. I remain to be convinced that, that the case is otherwise. At this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Ms. Zelaya? Do you have anything you wish to add? No, I do not. Thank you. Mr. Cisneros? You have 3 minutes.
Thanks again for hearing this complaint tonight. This just shows how blatant the MTA is failing to comply with the Sunshine Ordinance. They selectively disclose what they want to do, when they want to do it, to who they want to do it. I would hope that the task force give an order of determination tonight for that report and all documents pertaining to this situation. Thank you.
Thank you. The matter is back with the task force. Is there a motion? Member Wolf.
I move to, let's see. Just a moment. Okay, since the person named is Carolyn Celaya, that's the only person that we can focus this on at this point. So I would find in violation of section 6721, 6726, 6727, 6722, 6722 because where there is no written documentation, oral can be provided.
Is there a second?
Can you do 6721? Can you explain that? Wait.
6721 for I'm sorry?
I think
Just for getting access to the records. He was not provided with any of the records at all. He had no way or no recourse to be able to get access to those records.
Chair would like to ask why 67.27? It seems to me that there was justification made for the withholding. Yeah. They cited a number of statutory and case provisions.
The question is that is it just the mere justification that it said, or does it have to be justified that it exceeds the Sunshine Ordinance?
Well, they provided written justification. You know,
yeah, I think
we can disagree with the justifications that they provide, but it seems to me that 67.27 has not been violated here.
So, because they cited 6254C of the PRA,
that's correct.
You're saying that that's enough? Okay, fine. All right, so
They
scratch
cite both
6727.
Okay, Member Cawthon?
They cite both the Constitution and CPRA, so even if we don't agree that those are valid citation, it's their justification for withholding.
Okay, so right now we have on the table 6721, 26, and 22. Is that correct?
Mm-hmm.
Is there a second?
I'll second.
Moved and seconded. Discussion. Is there any public comment on this item?
Just briefly, Thomas Piccirillo. I'm in agreement that MTA has violated the Sunshine Ordinance again. My only concern is that, though, you know, if there's an issue of accountability, this complaint is against MTA, you know, the corporation. Is that going to achieve the accountability? I thought Ms. Celaya's testimony was her supervisor instructed her not to give the documents that were requested. If that's the case, then the supervisor should be named in the order of determination. If there's a complaint against MTA by itself, that's not going to, I don't believe, get you the accountability, and there'll be more MTA cases in front of you. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion?
Yes.
Member Wolf, Member Snyder.
I would just say with regards to who this has to point to, you know, it's the complaint is made against somebody, against the custodian that is being named. To bring in other names would demand us to do further investigation and give notice. And we've been through this before. And I'm okay if you want to do that and continue the item and contact other people who, but I don't think that's necessary at this time.
Member Snyder?
So, as to the 6721 and the 22 violations, 6721 really lays out the process by which all of this, the sort of general framework of the records portion of the Sunshine Ordinance. To the extent that there are any provisions that are capable of being violated, they're pretty general, and I don't think they've been violated here, in my opinion. 6721B provides that a custodian of public records shall comply with a request, which I read as saying that they acknowledge and respond to a request, which I think has been done here. I think the MTA responded. And the rest of 6721 really just lays out the process. And as for 6722, what that section does, I think, all that section does is say that there needs to be, every department head has to designate somebody who's devoted to sort of public affairs to releasing information. And I don't think that's, I mean, I think the only way you could violate that, an agency could violate that, would be to not appoint such a person. So what I'm saying is I would support a violation of 6726 based on the fact that there were records that could have been redacted and released that were not released after being redacted. They were just simply withheld in their entirety, where the stated basis for that was invasion of personal privacy, where I don't see none of the testimony today supports that withholding for the entire document. So I would support a 6726, but not 21 and 22, although I'm open to persuasion on those.
Member Wolf?
In 6721, it's described in 6720B that public information is either oral or written. In the very first sentence of 6721A, it says every person having custody of any public record or public information shall at normal times, without delay, and without requiring an appointment, must produce the document. Okay, we heard here testimony of oral information that was not presented. It was withheld. And if you go down to C, C says a custodian of public records shall assist a requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall.
Sorry, where are you, Bruce? You're on
6721C.
C?
And when requested to do so, provide in writing within 7 days following the receipt of the request a statement as to the existence, the quantity, form, and nature of the record, so on and so on. I think it's pretty clear 6721 applies.
But if you limited it to 6721C, I was going to make that suggestion because the last sentence, a custodian of any public record when not in possession of the record requested shall assist a requester in directing a request to the proper office or staff person. And Ms. Antonio said that the MTA doesn't handle the camera maintenance logs, and nobody told Mr. Cisneros where to go get them.
Agreed.
Are you proposing a friendly amendment then? To specify it to C?
Yes.
Does the second accept? Maker accept?
Yeah.
Amend.
So we're saying
Amended to
6721.
6721C.
Because they have a right of
Fine.
requirement.
Okay, and on 67, 6722, which Member Snyder also found problems with.
Well, oral information that does require them to turn over oral information.
Where? Point me to where it says that.
Okay.
6722B.
We found this once before.
6722 says, every department
No,
head
read B.
the role of the person or persons so designated shall be to provide information on as timely and responsive a basis as possible to those members of the public who are not requesting information from a specific person. This section shall not be interpreted to curtail existing informal contacts between employees and members of the public when these contacts are occasional, acceptable to the employee and to the department, not disruptive of his or her operational duties, and confined to accurate information, not confidential by law.
Yeah.
That's interesting because we make them request it to a specific person sometimes.
Yeah.
But
I mean, I just read that as laying out the process for
I will tell you that the
appointing
Good Government
somebody.
Guide, which Chair Nee has, agrees with Member Wolf.
Does
I just
it?
read it last night.
Okay.
And Mr. Chair, I would also contend that in A, every department head shall designate a person, so on and so forth, including oral information to the public about the department's operations, plans, policies, and positions. This is what Mr. Cisneros was asking for. He was asking for documents with regards to operations.
Sure, but all I'm saying is that all the
Snyder.
provision says is that that a person will be designated to do that. For the provisions that we generally find violations of, they say things like 6726 says, no record shall be withheld from disclosure, et cetera, et cetera, et cetera. You can violate that section.
Okay.
But if
Well, you want to add that?
if I don't know, I just don't see 6722. But
You can look at it. You can look at the Good Government Guide online. You can look up where it says that they point to that, and maybe it says it more the way you're saying it, but you could look it up if you wanted to, just to double check. They do address it. It's in in the last section.
Mr. Chair, I honestly think that this
Member
is a
Knebel.
very small point that we don't need to belabor.
I agree.
think that it's fine.
I agree. I mean, I think the important one is 6726. I think 6722 it could be interpreted the way Member Wolf is interpreting it. I don't have a problem. I don't want to hold up this process because I do think that's a valid reading of it. Member Wolf's reading, that is.
And 26 is in there too for the redaction.
Okay, so the motion as it stands includes 6721C, 6726, and 6722. Are there, which paragraphs within 22? Which
I would say
B.
C.
B.
Is it C? 22. No, it would be B. 6722B.
Okay. Further discussion? Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Knebel? Knebel, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes. The motion passes.
Thank you. This matter is referred to the Compliance and Amendments Committee. Thank both sides for your attendance. At this time, we're going to take public comment on items not on today's agenda. Is there any general public comment?
Good evening again. Just a procedural issue. I'm just curious how Mr. Cisneros got on your calendar tonight in this special meeting. If you recall, the last regular meeting you had, there was probably 6 or 7, if not more, complainants that didn't get their matters heard. and I'm just trying to figure out how Mr. Signeris is on your calendar and not the other complainants that didn't get their matters heard in your last regular meeting. Thank you.
Thank you. Is there further general public comment? Seeing none, general public comment is closed. Mr. Piccirillo, I will respond to your question. At the last regular meeting, Mr. Cisneros indicated to us that the resolution of his issue was time sensitive. Nobody else gave us that kind of that sense of urgency. And I did want to keep the complaints on tonight's agenda to a minimum because we still have the amendments, ordinance amendments to discuss, and I expect that's going to take us some time. Thank you, sir. Mr. Clerk, could you call the next item, please?
The next item is consideration of amendments to the Sunshine Ordinance.
Okay. Just by, to open up the discussion, I did type out a little summary starting on page, packet page 30, kind of a progress report on where we are. And if you look on page 33, toward the bottom, we have the issues awaiting deliberation. We also had some, I think, further back.
I sent
I
in
guess not.
something.
I'm sorry?
Are you looking for the amendments? I sent in some amendments. Based on the depth.
I'm sorry?
I had a McKella Elliott of Pure Moment. I got lost. I thought you were looking for the other amendments.
No. I just wanted to point to the summary that I've provided just as a kind of a starting point for where we can kick off the discussion. So, starting with sub-item number 7 under issues awaiting deliberation. Members Wolf and Costa agreed to draft language for an amendment regarding electronic document storage, and I'm wondering if you can provide us with a progress report on that now.
Yes, I can. I'm sorry I don't have copies for everyone because they brought the wrong computer, and when I went to print it out, I didn't have it on this particular machine. But I do have all the items that I would want to include, and I can provide them in writing. If it's acceptable, it probably needs to have some wordsmithing done. But if the overall sentiment seems acceptable, then I'll provide the written document. For documents, I'm calling it kind of documents management and storage. And this would be all documents created by the City and County of San Francisco. Sorry? Okay. This would be all documents created by the City and County of San Francisco within jurisdiction and force of law under the CPRA, Brown, and the Sunshine Ordinance, and that they are public. All city entities shall have a means to store, backup, and restore all documents it produces electronically, either organic, scanned, or otherwise. I just want to say that Member Costa and I did work together on this. Organic meaning, originated, created from scratch. B, that all public records in the custody of a custodian of records shall make available electronically and on the website, and I would add, I'll explain that I want to add an extension to the word website, and I'll explain that later after I'm done with this. Again, all public records in the custody of the custodian of records shall make available electronically and on their website, the website designated to their department, according to the index of records as directed by the Sunshine Ordinance and provided by the supervisor of records. And then a sub-paragraph to that, public documents shall be categorized to increase public disclosure and self-facilitation for access by anyone. New paragraph C, upon request by either a requester of public records or the Sunshine Ordinance Task Force any and all public records where the documents are archived, a means of restoral and reproduction of the original aspects as specified in 6721, which is speaks to like metadata and all the original aspects of a document, shall be made available to the custodian of records, and the custodian of records shall produce those requested documents within the guidelines of the Sunshine Ordinance. Now, what this means is that one of the things that we have found out over the years is that a custodian of records may not have all the tools available to them to be able to produce or reproduce the documents that are, or the records that are being requested. So this kind of puts the onus on the city to provide every custodian of records a means by which to be able to get those records. So they don't show up here saying, I don't have them, I can't get them. They're in storage in Iron Mountain, or they're buried in some server they can't get access to. Because of the evolution of the city's information systems now that we're learning about, it'll be a lot easier to get access to those, and that backups and restorals will be a lot easier. So not only do we want the public, or the requester by the public, or the public requester, to be able to get the records from the custodian of records, but we want the custodian of records to have the means by which to be able to get those records too, and have it accessible. So that's the purpose of that paragraph. Last paragraph is that all documents shall be made available for public access electronically and or on a website. Now, in addition to just forward thinking about the word website, that's in today's terms. It's kind of a slang term, even though it's probably included in some dictionary somewhere. But I think what should be added on to that as an extension is website or other electronic means of public access. And I think it's important to put in these forward-thinking kind of statements, because we don't know what's coming, and that we don't have to revisit it and send it to the voters again and again and again. We try to leave it as open-ended for those particular mediums for access. So that's what we have come up with regards to this. Is there anything you think we might have missed?
Hard to take.
Just briefly, are you putting any kind of time frame on the storage of records? In other words, would it be all records created, or all records should be stored for 3 years or 6 years or anything like that?
Well, Mike, I couldn't find any information with regards to records retention, and I don't know whether the ordinance has jurisdiction over that or whether it's contained somewhere else. So I didn't contain it in there, but in the previous section, under section 6721K on page 32, I did make some suggestions for that with regards to converting old records into electronic documents that are searchable, because that's a painstaking process to be able to take a hard copy, scan it in, and then have special software called optical character recognition convert it into text. Lots of times, if it's not a clean image, it has to be manually reformatted. It's a painstaking process. The question is how far back do you go that's meaningful for the average, or let's say the 90th percentile of records being asked for today? And if you could figure out what that 90th percentile is today, that would be the starting point. Anything beyond that, if it's a hard copy, you're not going to find that much metadata attached to it. But I've been working with metadata back into '95, so I don't know when the city had started doing things electronically to the point of using metadata, and that would have to be researched. I just find I'm not necessarily prepared enough to be able to answer that question.
Okay, and just one minor correction, it's 67.21L, not K.
That's what it's in your notes, it says K. It's K, it's the one underneath L. It says converting records to electronic format.
Where on, you're on packet page 32?
Package page, at the bottom.
Oh, okay, thank you.
That's on the converting a
Right,
record, because
got it.
that's a process work
Right.
that people have to do. And
Okay.
again, in that section, I would suggest that that the city must provide the globally to everyone ample technology that allows them to achieve the ability to perform this function. It can't be on a at the COIT meeting I went to, that was seriously a problem, that every department buys their own software. So there's no standardization, and for this particular purpose, there must be some sort of standardization.
Okay. Thank you. Member Costa, did you have anything you wanted to add?
I don't think so.
Okay, thanks. Thanks very much for a very complete accounting on this. This is very helpful. Is there any public comment on this particular provision? Thank you. You have 3 minutes.
Yeah, I do like the idea. Nowadays, some information isn't on a website. Sometimes it's like in a cloud or whatever. So you go somewhere and then all the information's there. So I think some of the text is good.
Thank you. Is there further public comment? Seeing none, public comment is closed. Member Wolf, what I'm going to ask is that you send us through Mr. Rustum the language that you've drafted, and then we can incorporate it into our package.
Okay.
Okay.
I do, Mr. Chair, I do have a number of other small amendments or type changes or additions that I'd like to also introduce. Is this the time?
In this particular item?
It's not in that particular item. It's items before this one.
Okay, what I'd like to do is finish what we have
Okay.
under issues awaiting deliberation.
Got
Then
it.
we can go back.
Perfect, thank you.
All right? That takes us to item number 8 then, or sub-item number 8. Whether the task force should be authorized to hire outside counsel. The consensus solution we have agreed to is to draft a provision under Sunshine Ordinance Article 4, authorizing the task force to spend up to $50,000 a year on outside counsel and stipulating that the task force is encouraged to seek pro bono counsel. What we need to determine are a specific section number and language. And one thing that I want to put out there right off the bat, I think a provision of this type would need to define specific circumstances under which outside counsel could be brought in, and the official powers, responsibilities, limitations, and prescriptions of that counsel, of that counsel's activities, would have to be defined. I think if we don't do that, I would have a problem going along with it. If I'm a member of the public and we're proposing to spend $50,000 a year on outside counsel, it's a drop in the bucket amount, yes, but it's every little straw contributes toward breaking that camel's back, and something like this, even if we authorize spending of $1 a year on something like this, it's going to bring a lot of opponents out of the woodwork, so we have to be very careful on this one. Now, I personally have not sat down and drafted any language, although I believe that in the package that was put out there in 2008, I believe Member Craven Green had introduced some language. Unfortunately, I don't know if I have it with me or not. Does any member of the task force happen to have it with them? Member Wolf?
I don't know if I have it on this computer. It's too new. Is it part of our package?
No. I don't believe so, no.
It was from before.
Member Johnson?
I remember when we were having our conversations about what to try to include and what not to include. Is this one of the ones where we had the discussion about ask for multiple things and then you can take some of them out? So that's why we're including this?
To the chair.
Member Knebber, Member Knebber.
This is one of those ones that I have a little bit of unease with, just because of that money ask. But I agree. I think that it's one of those things that we should write and have, and then decide if we're going to keep it in until afterwards. Because I definitely think it is a direction that some people on the task force want to go. Again, I am not 100% at ease with it, but I do think that the discussion that I remember is that we were going to write it and then see where it went.
Mr. Rustum?
Cheney, if you call a 5-minute break, I can run down and get a copy.
Is that agreeable? Okay, we are recessed for 5 minutes. Thank you, Mr. Rustum. We're back in session. I have in front of me the amendments that were proposed back in, I believe, 2008. And under it would be new section 67.40 administrative enforcement provisions. Paragraph D for David. 1. Upon finding a serious and willful violation of this ordinance, the Commission, by not less than a 2/3 vote of the voting members, may appoint outside counsel to prosecute the violation or violations of the ordinance by bringing an action in the civil courts to the extent permitted by the city charter. 2. The amount of expenditure for outside counsel to prosecute these cases shall not exceed $50,000, that's 50000, per fiscal year, or such greater amount authorized by the Board of Supervisors, parentheses, litigation fund. The Commission shall include in its bylaws criteria for selection and oversight of appointed counsel and expenditures. 3. If attorney fees are recovered in litigation proceedings initiated under this provision, fees in the amount paid out of the litigation fund to outside counsel for the litigation shall be credited back to the litigation fund. And that's it. Is there anybody who wants to take a look at this? Or are you all clear on it? Okay.
You feel like that covers it?
Member Knibber.
I that completely rings true again. I remember the first time I heard this, the question I had was about outside counsel, not just prosecution or outside hiring for litigation. I don't know if we need it, but that might be something that because a lot of our problems, we get a lot of attorney opinions pro bono, of course, or just asking, but I don't know if we wanted to make that included in there in case we wanted to be able to have the option of using some of that money for beyond just the litigation aspect.
Okay. Do we want then to adopt this language in the new 67.40 into our package, or do we want to change it somehow, add, delete, amend any language, or do we want to leave it out? Those are our choices. And again, I think we're of kind of two minds on this. Number one, we know that this will be a politically hot issue if this goes on the ballot. It will be a politically hot issue trying to get it by the 4 supervisors we're going to approach. But I think we also agreed that we want to approach the supervisors with as strong a package as possible and figure out where which areas we'll be willing to sacrifice. Member Knebber.
I like the language. I do think we need to put in specifically about the pro bono clause that is not included in that.
Okay.
And I would still like to put, just to open it up a little bit, just say not only litigation but also for counsel, because that just opens up the availability to use those funds that are beyond just prosecuting a civil case.
Yeah, I agree, that's particularly important now with the deputy city attorney assigned to us limited in the number of hours that he or she can serve in our behalf. So, Member Snyder.
It might just, without having it in front of me, I'd be happy to take a crack at adding that. we could just add some phrase about, I think what you're getting at is legal advice. Is just say, you know, where is it? Oh, right.
But also to make sure that it's clear that we are always looking for pro bono advice or counsel first before using that money. I mean, that has to be explicit in there.
Okay.
Yeah, this would, I wouldn't be able to do this just sitting here. It'll take me a little long. It's a little late in the day, but if we still have time, I'd be happy to take a crack at just plugging in legal advice also. And the problem with adding this is that she set this up so that it all depends on a finding of serious and willful violation of the ordinance. So I'd have to maybe draft a. Anyway, I can take a crack if y'all want.
Okay. We may be getting a bit, you know, we're getting close to crunch time here, but there's, you know, the other thing is we could put this off till next year. At this point, we've waited a long time, I know, and that the length of that wait is very frustrating, but we may actually have a better chance at getting this through if this goes on the ballot next year. Member Kneber?
I agree, but I still don't think it hurts to push forward right now.
Oh, absolutely.
And this actual clause, I personally think that there is not a chance that this part will go through or will be accepted by a supervisor, but I still want to put it in there and try it. So I am not as concerned about it being, you know, that one, this clause being completely put together. If we have to go forward without this part, I'm fine with it, but I do think that we need to push forward with it.
Okay. Member Johnson?
I was going to say essentially the same thing, that we could hope that we have enough time to include it. But if something happened or you found that it would take longer than we could always push forward without it.
Okay.
I don't know what the time frame is that Member Snyder would need.
I mean, I could do it probably this weekend.
Oh.
Fine. Okay. That takes us to paragraph number 9, contract preparatory requests and responses. Mr. Rustum?
Public comment.
On number 8? I think we had it, didn't we? Oh, well, is there public comment on paragraph number 8? I believe the audience section is empty. Okay. Paragraph number 9, contract preparatory requests and responses. Chair Wolf and Member Johnson, we're going to research the matter, and Vice Chair Wolf and Member Johnson, we're going to research the matter, draft alternative language to 67.24E1. Have you been able to move forward with that? Member Johnson, Member Wolf?
Okay. As you know, probably, you know me now, I've been following the Stowe Lake case pretty closely because we had so many hearings about it. So in light of what happened today, I think that it would be premature for us to try to change this. My suggestion would be.
Can you please qualify that?
When the plaintiffs in the Stowe Lake case received their documents that they had been trying to get through us for a long time, it turned out that the well-known, who I also volunteered with very closely, Alex Turk, who was the deputy
mayor.
He was the deputy mayor under Gavin Newsom, had lobbied, it looks like he lobbied one of his ex-clients, Dennis Herrera, to promote the company that eventually won the proposal. So it would be a case of illegal lobbying. But it would also open up a huge can of worms for them that they haven't even come to, which we got to, which was that Rec and Park was not following any procedure that Vice Chair Wolf and I could, in both of our research, we were having a hard time connecting up what is the procedure. So when I asked the redevelopment agency during the Stowe Lake hearings, their attorney contacted me directly in writing with their policy. They were on it, and they had all of this stuff on there about it. But as soon as that gets mixed up, like at the time I had mentioned Pier 70, which was months ago, but I was following it because I was doing this research, and now, of course, that's come up, and it's going to be very controversial. And now the redevelopment agency is getting caught up in the fact that our Rec and Park seems to have an odd relationship with these RFPs and RFQs and how they use them. But I think that there will be some, now the courts, the legal system is going to review the idea of whether these emails between Mr. Turk and City Attorney Herrera should have been disclosed, and were they legal? And I think that will open up some whole new areas for us when we go to revisit this. But I think rather than including I don't even know how to revise it after all of the things that have happened, but I would say that there is a provision, I don't have it off the top of my head, it's left me, in the Sunshine Ordinance that says that from time to time we can prepare reports. And I think we could weigh in and talk about how some of the provisions in here bias toward Rec and Park, and that if it comes out that Rec and Park had a preference, they had access to all of the things that they're keeping everybody else from having access to. I think when we were having the Stowe Lake hearings, Member Snyder was really good about parsing through this and gave us some pretty good guidelines about how they have to turn them over once it's done, but they could turn them over if they wanted to. It's just that they didn't have to until it's over. So we could, I think, weigh in a report form because we heard all that information about Stowe Lake, and we understand. So if someone, can come up with the can of worms that this is, I just thought that the court's rulings and hearings on that might be helpful.
Member Knebber.
I understand your sentiment, but I still think, a simple solution is just to include all this wording. That not only are we saying, put in requests for qualifications, requests for proposals, and any other requests from bidders. Something along those lines as disclosable.
Member Wolf.
My discussions with the contracting department is that the threshold is when the RFP is issued, when that is sent out.
But now that you're addressing the can of worms, because they sometimes don't issue an RFP, and they only issue an RFQ.
No,
That's
I
what
understand
makes it
that.
hard.
Let me finish. When I asked them about RFQ, they said it's not part of the RFP process. It's external to the RFP process. And they hear about these kind of wishy-washy things that certain departments take advantage of, but they don't have enough staff to be able to enforce. They don't hear everything all the time. The problem that I have with the way Rec and Park goes about it, beyond just maybe misusing it, is that they don't let anybody see it. They don't even let the Board of Supervisors who have to approve it, at the time of approving it, they don't even get to see it. And that, to me, is extremely problematic, that they get to hold it, and they're the only ones that get to hold it. It's not public, even after the award has been made. That's bad. There's something
And
wrong
that's
with
my
that.
point about what's before the court now, because Rec and Park can be seen to have had a preference for one of the bidders.
Mm-hmm.
And they actually recommended a consultant, a lobbyist, to those bidders. So that is more, that's evidence that what you're saying needs to be addressed in the Sunshine Ordinance, although some of it is policy, city policy, and we don't have
I do.
control over that.
But I have the sections of the code that describe how this process works, and RFQ, not part of it.
And we even have a document with Mr. Kinsey, who's involved in all the controversy, saying that the RFQ and the RFP is different, even though in front of us he said they were the same.
No, he said that they use them in the same. They are allowed to use the RFQ as an RFP process, but didn't describe.
But in his public documents to the Board of Supervisors, he specifically says they're different and that he chose the RFQ because the RFPs were not working.
Right.
So that my point is really just, it's very difficult to figure out what you would add or subtract to make it more open outside of the board or the city changing its policy to help prevent, I understand the proprietary information, but then there are other pieces of information, and they'll have to address that if it comes out that Rec and Park had a preference for a bidder, because they're the only entity with access to that information.
Well, that's why I would say that anything external to the RFP process. Now, the RFQ process, RFP and RFQ are not the same, so they can't talk out of both sides of their mouth in saying that it is. The RFQ doesn't talk about money. It talks about whether you can do the job or not. So where's the negotiation? Unless they're saying that it was there's only this one company that does it in the 50 states, contiguous 50 states or 48 states, and no one else does it. That's the only way they can bypass and go to a sole proprietor, a sole contract, which this sounds like they tried to do.
Well, they do have RFQ procedures for smaller contracts. That's the only provision that.
But according to the city's own contracting department, that's incorrect. RFQ is meant to find out who you want to send the RFP to, so that you're not wasting your time. That's what the purpose of an RFQ is. It has nothing to do with money.
I'm just saying that if you go to the contract website, it literally says on there, which you might point out to whoever it is that you're talking to, it literally says on there that like court reporters, supplies, that those never go through an RFP process, that they only go through an RFQ. It literally says that on there. But those are those particular, yeah.
They specify specific.
So I find it difficult to change this but we could do a report from the task force eventually saying all the things that we're saying now and detailing our research and adding as more information comes out. But because some of the information is proprietary, and even if we put it in there, it would be illegal. I mean, it's I don't know what law that is, business law, I don't know, proprietary.
I don't know what provision keeps that.
Something outside of us. Trademarks and propriety and inventions.
Okay.
Some of it might be trade secret law. I don't know.
Member Kneber.
So what I'm hearing is we want to pass this over for now and see what happens.
I think that
Okay.
that's the consensus.
I think that we should move on because I think I don't think we're going to
You
get
don't
any
mind
farther
that?
with time about.
You don't mind?
No.
Okay.
Is there public comment on paragraph number 9? Again, the chair will note that the audience section is empty. Paragraph 10, record withholding justification. Member Snyder agreed last time to draft language for inclusion in ordinance in section 67.1. Member Snyder.
Yes, it's on packet page 35. I tried to do a minimalist job here. My additions are in all caps. It's a 67.1D, and all I was trying to do is to establish in the sort of preamble to the Sunshine Ordinance, which is more or less what 67.1 is, that the burden is on the agency to provide a justification that for withholding the record. And so the language reads, you can see it right there, but department records shall be made available to the public unless the department demonstrates that the records are not disclosable under a legally recognized exemption. So there it is. I looked at Prop 59, and I didn't see anything that I just didn't see a good place to put any of the Prop 59 language. And in fact, subsection D, where I have suggested this language be added, in fact, kind of encompasses some of what Prop 59 tries to accomplish. So what I'm saying is the language is already there to some degree, the Prop 59 language.
Yes, Member Kneber?
All that I like this. I think it's very clear. All I would like to add would be that the word cited.
Cited.
Recognized and cited.
Oh, yeah. So that encompasses the 6727 requirement for, I think it's 27 for.
Under legally recognized and cited exemption.
Yeah. Uh-huh. That's.
So they can't come back and say, hey, it's recognized, even though we didn't cite what it was. We just can't be after the fact.
Good idea.
Yeah.
Further discussion? The chair will again note that the audience section is empty. And I think that takes us to paragraph 11. Certain terms in the ordinance have been identified as needing defining or explanation. And I think file and complaint were among those specifically identified as needing those kinds of amendment. Member Johnson?
If you go to packet page 36, when I was trying to define these and was trying to consider the definitions we might use and the best place to include them, I started thinking that maybe a better choice would be to change 6735. And in looking at that, I realized we had included some of the undefined terms. This is all based on the fact that the Ethics Commission comes back at us with the terms defining them on their own. So some of the things we proposed used definitions that were also not defined. So section 6735, the former member Craven Green had suggested using the word commence instead of institute, and I thought that maybe we could use that because in section C, if a court finds that an action filed, so there's that filed, but if you put commenced pursuant to this, then it's consistent, the language is consistent. And then at the end, where this came from, D, there might be a better way to say it, I don't know, but this is where it came from, the Ethics Commission saying that they didn't have the definition of file and complaint. So any person may commence proceedings for enforcement and penalties under this ordinance, which is just changing it to make the language consistent. In any court of competent jurisdiction before the Ethics Commission, if enforcement action is not taken by a city or state official 40 days after such official receives a determination from the Sunshine Commission, because we might change it, Sunshine Task Force, the Ethics Commission, or a court of competent jurisdiction that the person's rights under this ordinance have been violated, instead of saying complaint. Because we use the word complaint, but it isn't used anywhere else.
Member Kneber?
I would agree with that. I think it's a bit picky by the Ethics Commission to point out that they don't understand what file means or what complaint means, but I would agree with just making the language consistent. And I think this right here, this section, I think it covers what that means well enough. I'm not that worried about it, honestly.
Well, it's just that one of the ways, to avoid, this was added after the authors had completed it, so it used some of the new people's language. So one of the ways to avoid them being able to say, well, we, shrug their shoulders, whether it's intentional or unintentional, whether we think it's purposeful or not, it's still the way that almost all of their rulings are done. And then based on that, these are some of the, I don't know if you want to wait until we go back, because I know Member Wolf had said that, but just to point out, I have some some things down below because of the rulings that just recently came out that we were writing about, the Warfield versus the Library Commission, where they said that our committee doesn't, the letter we just talked about, that our committees don't count because they're not, they were looking around for a place where the ordinance required attendance at an additional meeting. So I kind of added that in there while taking out the, the language of complaint and file. And in doing that, there were two other sections that we proposed that we used phrases that we use but are defined nowhere in the ordinance. So I kind of went through those. But if we go back to that, like if you go to 37 of our packet, 67, 20, and I made the two paragraphs identical because if you look at their previous versions, they use separate kinds of language. So for 6721F and the third line, we had said alleged in the complaint. That was our newly proposed language. But that 6721 discusses a petition. So I put petition in there instead of complaint. And then 6718 is another newly proposed section. And we have, again, it said concerning a complaint. So I pulled complaint out of there, concerning alleged violations of any of the foregoing sections. And then it also says an authorized representative of the body or person named in the petition, because it originally said named in the complaint. Or it's just very complicated, because I know they'll latch on to, like in the beginning of 6721F, our original proposal was an authorized representative of the respondent, and the respondent isn't defined anywhere, nor does it say in 6721 the word respondent relative to the authorized representative coming to. We know what it means, but I'm just trying to correct the petition.
I'm very happy that you're doing this, but I guarantee you that they're going to find 1,000 other places to latch onto. I think that this is a losing game to track down each.
It's not. This is what they do in court. It seems like they do big fancy things, but this is all they do.
I'm not saying that. I'm talking about the Ethics Commission is going to find reasons. We can have straight and fast language all the way through. So I don't think that parsing each and every word down is particularly useful, because it's not going to stop the underlying motivations of the Ethics Commission in responding to our complaints. I mean, they're going to find other reasons besides the wording.
They might, but I think it would be nice not to have. If we're going to propose it, at least not use the word complaint, use petition, because it's already in there, if nothing else. I think that they hardly ever come out and discuss the validity of the law. They tend to latch onto these words. But
okay. The chair will again note that there's nobody in the audience section. And I think this takes us pretty close to a wrap. I think we're all consensed on Member Johnson's amendments, amended language. So we're pretty close to a wrap, and Member Wolf had some items he wanted to raise.
Okay, so going back onto page number 32. In the new section 67, the section 6721, some of the additions. First, I have a question.
Which one, 21L or 21K?
L, I'm sorry.
Okay.
In the middle. The third line, it says, after the underline, new sentence, inspection and copying of documentary public information. What does documentary mean? Should it be documented public information? Or should the word
6721L line 3.
Or should the word documentary not be there?
I think it makes more sense if
yeah.
Okay.
is that already in there?
It was already.
It's in the current language.
It's in the current language. I would just. I don't think it's
delete
necessary.
it. Okay. So the consensus, without objection. consensus to delete documentary?
Right.
Okay.
And then further on, let's see, 1, 2, 3, 4. The fourth line from there, where it starts with disk, comma, tape, comma, printout, or monitor. If the sentence basically is talking about generating generating the information, and I'm not quite sure. I mean, CD and DVD need to be included. I'm not sure what monitor means.
In any form.
Right, sure, that's
Take
fine
out
too.
all those and just say in any form so that we can't come back and somebody makes something new and they say, well, it doesn't say we have
Right.
to do it.
So how about any form or media?
Where,
So this is
Above the sentence right above the second underline.
right.
and this is in where, 6721?
L.
L, okay.
So the sentence begins disk, comma, tape, comma, the line starts. Disk, comma, tape, comma, printout, or monitor at a charge no greater than the cost of the media. So I guess include it in any form, easily generated by the department, its officers, or in any. So strike including disk, tape, printout, or monitor, and replace it with in any form. And the cost of the media. Okay. The next line, beginning with metadata and the underlined, metadata contained in, I think it should be any electronic form, are officially deemed part of the public record. Are you with me? Everybody? Okay. All right, and then,
There's another documentary in the
is there?
It's
Okay.
right after the end of that underline, inspection of documentary.
Oh,
public
all right,
information.
got it,
Strike that documentary.
okay. And then, I think in this section, with regards to metadata, it talks about disclosable and non-disclosable portions. I think even though other sections of the ordinance say it, I think it needs to be repeated that anything that is felt to be non-disclosable must be accompanied by a reason, where cites some statute.
I think we should use the same,
Same
language as Snyder's edition before. Recognized, legal,
Recognized and cited?
Right.
recognized and cited legal.
Yeah, it's a good sentence.
Under a legally recognized and cited exemption.
Right. So I would add that. I don't know where to add that, though. Except because the last sentence talks about protection under licensing agreements or copyright law. So it should probably come somewhere before that sentence. Or you could say notwithstanding the above or something. I don't know if that's the right word.
Well, what we could,
Notwithstanding.
we could insert the phrase, under a legally recognized and cited provision after the word non-disclosable portion or portions.
Okay. Okay, tell me when you're ready for the next one.
Okay?
All right, did I already talk about K? No, I didn't. Okay, so.
Not yet.
In the next section, 6721K, when responding to sunshine ordinance or public records request, every department and policy body shall, if requested and if necessary, technology, comma, software and equipment are available. Convert documents that are otherwise available in hard copy paper form, in so on, searchable electronic format. Now, one of the concerns I have about the particular area is that it is how it gets performed. And and because you have a problem when it comes to converting records. When you say converting records, are you converting hard copy into electronic format and then making those searchable? That's like a 4-step process to do in today's technology. So you have to have the physical document, you got to put into a scanner. It comes out as a TIF, an image, and then you got to put it through an optical character recognition system, which then converts it to text, which then you can put into a word processor, which you then have to put through a spell check, and then manually format it, correct it, okay? And then you have to match one for one with the original document. And that's how you would make a hard copy into an electronic document. So, go for it.
I understand that, but I think this is more of a future. That's why that clause is in there, if necessary technology, software, and equipment are available.
But it doesn't make it mandatory. They could say, well, it's available, but it's not available in the building. It may be available out in the world, and it's been available since 1995. So, the question is they don't have it. And Mike, again, this goes back to the kind of the idea that by this time, everybody should be able to be doing it. And if they're going to create this big, huge, brand new, centralized document management system, then they have to have some way of a form that was filled out by hand to be able to get into that center in some way.
I have a feeling, though, this is a big, and I understand.
Member Conover, could you talk into the microphone, please?
I understand your concern, but this is a huge, huge discussion. It's not just on this level, and it's about city policy and I understand you're trying to affect city policy by our bylaws, but I don't know how you would word it to be able to make the impact that you want.
Well, but by stating conversion of records to electronic format, it's kind of, then what it needs to be said is if necessary technology, software, and equipment are available. I think that we need to update that by saying the technology, software, and equipment must be made available in order to convert documents. Like, it needs to be done now.
So maybe we cut out that clause.
Would it work would it work just as well to cut out that clause? And if necessary, technology, software, and equipment are available. Just
Okay,
strike that clause.
Okay, so when responding to Sunshine Ordinance or public records, every department of policy shall convert documents that are otherwise available only in hard copy form into a searchable electronic format. Okay.
And if they come back to us and say we don't have it, okay, well, you need to start getting it. That's our push.
Okay. Okay, that's fine with me then.
Okay.
That's fine.
Anything else, Member Wolf?
And then on page 33, in the same paragraph at the top, second to last sentence, after the word website or other electronic means of public access, as appropriate. And that just saves us from future technology or something we don't even know about yet. Johnny Mnemonic. Implants in our brain. What?
Mr. Rustum?
Through the chair, Member Wolf, could you reread the sentence that has the disk, tape, and printout or monitor? Please.
Yes, it's on page 32, section 6721L, sixth line down, starts with the word disk. It says disk, tape, printout, or monitor. Is that what you're talking about?
Through the chair, yes.
Okay, so we're striking the word before disk, including disk, tape, printout, or monitor,
Thank you, Mr.
and then replacing it with the three words, in any form. So it's a strike and replace. That's it. That's all I got.
Okay. Does any member Costa?
Could Member Wolf repeat the website, or what is the exact wording for?
Or other electronic means of public access. Or maybe it should be, or any other electronic means of public access.
So the only concern, I agree with the spirit of that. The only concern I have is that, does that sort of leave a loophole for something else that exists now that is not as accessible as a website?
Okay, so how about, or other future electronic means of public access? But then they'll say, well, we sent it out over smartphones, but not website.
Chris, did you need this back?
Or we projected it on the side of City Hall. Or we put it in a PlayStation.
So where are we now? Are we still with or other electronic means of public access?
It's or other future.
No, I don't like the word future.
You don't like the word
future?
Neither do I.
I think other.
Just,
Or
or other electronic means of public access.
Okay,
That's
Because we may have something in the present.
all right. I'm okay. If
Okay.
if the way it's going to get interpreted is the way Member Knebber says it is, then I'm okay with that.
Anything else for the good of the order? Okay. Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair, the next item is
Number 6, I believe.
number 6 is announcements, questions, and future agenda items.
Okay. Any members? Member Knebber?
I will not be able to be here for the next special meeting.
Okay.
It's
Member
likely,
Money?
it's unfortunately likely that I may also not be able to make.
Okay. Member Costa?
As I indicated in my email to you, I would not be able to come till later,
Till later, meaning what? 5?
probably around
6.
6.
Okay. Noted. Motion to adjourn? Thank you all for coming.